Well, hi, everybody. I'm Kendall Berman, and I am a counsel in the DC office. I focus on cybersecurity and data privacy, and I'm thrilled to be the cap on this day of extremely interesting and diverse presentations. Mark Prinsley, our partner in the London office, and I are here today to talk about GDPR and the Privacy Shield. In case that sort of gobbledygook of code words doesn't make sense to you, we're here to explain it, but the GDPR refers to the new law in the European Union that can also apply to U.S. companies and relates to data protection obligations. And the Privacy Shield is one of the most popular ways U.S. companies can legally transfer data from the EU to the U.S. And there's been a lot of significant developments over both in the last few months, and so we're here to give both a little bit of background, but also an update on some of the main issues with those. I'm going to turn over to Mark. He's going to talk about GDPR first, and then I'm going to end it all with a little bit more on Privacy Shield. So thank you very much.
Thank you, Kendall. Feels quite dangerous being the last people to speak after a very interesting day, and before you know, there are some cocktails on the agenda. Kendall, that's me. The GDPR is the General Data Protection Regulation. I've got approximately 25 minutes to talk about it. You'll be pleased to know it's got 99 articles and 173 recitals, so I'm not going to try and talk about very much of it. I'm going to talk about some key areas which are new in data privacy regulation, where there are new obligations on data controllers, that's people who who control data, and new rights for data subjects, that's people about whom data is held, all of which have cost or dollar implications for people handling personal data. So, very brief background. The GDPR is intended to harmonize the regulation of personal data across the whole of the European Union. It's due to come into force in May 2018. It was intended as Europe's response to the change in technology and the digital environment. Our data privacy laws dated from the 1980s, the thinking behind them probably dated from the 1950s, and everything needed to be updated. And that it certainly does. Whether it harmonizes law across all member states is something that is probably more in the talking about than in the reality. And in some of the stuff we'll talk about this afternoon, you'll realize that far from harmonizing things, it just creates disharmony in different areas. I thought I'd focus on 4 areas where there has been some guidance issued by EU and domestic regulators as to how particular bits of the regulation should be interpreted. I was thinking about this on the way here and thinking, well, why should you take any notice of any of this guidance from bodies which have got no role whatsoever under the GDPR? So one of the bodies that has been pumping out guidance is called the Article 29 Working Party, which is a working party of information commissioners created under the current EU directive. Well, that body is basically abolished the day the regulation comes into force, and if you try to go onto their website, you'll find their website is no longer being maintained. And why should you listen to a national guidance from a national regulator when the whole intention of this is to harmonize regulation across the whole of the EU? Am I doing something with this, perhaps? You're getting a few highlights in advance, probably. Sorry about that. Well, I think the answer, there are 2 answers to why you should perhaps take some note of this guidance. One is, search me, I've no idea, and the other is, well, there is nobody better at the moment, so it probably is worth listening to the guidance and thinking about how it might apply to your business. But don't treat the guidance as more than guidance. It's just to provoke thought, I think, because it just isn't. It isn't the law. So, as I said, the two key areas are additional compliance obligations on data controllers and additional rights of data subjects. So, more specifically, the four topics that I selected were data protection officers. Do you need to appoint one? That is a completely new role in most European countries. Do you need to conduct a data privacy impact assessment? That's something Rebecca talked about, and we'll have a bit more of a dive into that. Data portability, what are the circumstances in which you have to let a data subject take data away from you and hand it to probably one of your competitors? And what do the people issuing guidance have to say about consent for handling personal data? So the first one is, do we need to appoint a data protection officer? That is a completely new role, a new compliance role created under the regulation. Some countries in Europe had a convention of appointing data protection officers, but there has been, and there still is, no formal requirement to have a compliance officer called a data protection officer. Public authorities, which probably completely irrelevant to the audience, all have to appoint DPOs, but the private sector also have to consider whether to appoint a DPO. And what the regulation says is, if the core activity of the entity involves regular and systematic monitoring of data subjects on a large scale, or the core activity consists of processing on a large scale of sensitive personal data, that's quite sensitive personal data about health and criminal record and trade union membership, then you have to have a data protection officer. So what the Article 29 Working Party has issued some guidance on last month is what is meant by a core activity and what is meant by large scale. Well, dealing with large scale first, I had thought large scale meant quite large scale, and even quite large scale in a European sense, which means reasonably large, whereas I think quite for you means very large. But the guidance says quite large scale would include a hospital. A single hospital would be large scale processing, but the dentist would not be large scale processing. Now, I think that is a test which is quite low for large scale, but that's a matter of judgment. The interesting one is core activity. What is a core activity? When is one of those data processing activities a core activity? And again, they come up with the hospital example. The hospital actually features in lots of examples, but they say a hospital, processing of personal data in a hospital is a core activity of the hospital, because you need to know a lot about people in order to make them better. But it wouldn't be a core activity to be processing personal data in order to process payroll. So that kind of organization would, if that's all you did with it, then it would not be a core activity for which you would need to consider having a data processing officer. Oh, sorry, data protection officer. But what about, I flew here, and on the way here, I read the Aeroplane magazine, and the letter from the chief executive of the airline said, we put the customer at the center of everything we do. I don't suppose they're unique in saying that, but if you put the customer at the center of everything you do, it seems to me your core activity consists of processing personal data, and therefore you do need to be thinking about whether or not you should be considering appointing a data processing officer, a data protection officer. So that is a much lower standard than I at least had been thinking a month ago. You can voluntarily appoint a data protection officer, but if you do, then you sign up to lots of obligations. So you do need to think about whether you want to do that, but there's no black and white test on all of this. If you do appoint a data protection officer, then the guidance suggests that the data protection officer should be located in the European Union. That may be awkward for you if you are not based in the European Union, but you are caught by European data privacy law, which you could be. There are no set qualifications for a data protection officer. They should obviously know about the law, and if you're doing a lot of processing and you're moving personal data internationally, then you should have a higher level of comprehension of data privacy laws to be the data protection officer. The data protection officer's duties mustn't, he can have other roles, but they mustn't conflict with being a data protection officer. So you couldn't appoint the head of information security or probably the IT director, because they actually got an interest in how data is processed, and they would clearly have a conflict of interest between the two roles. The role of the data protection officer, well, it's broad. They are involved, they're part of your privacy by design solution, which again is a new concept in the regulation. They liaise with the information commissioner. They should be involved in everything you do relating to personal data. It's probably likely that it will become conventional to have reports from data protection officers in annual reports of companies, like you have environmental impact or corporate governance reports, saying how personal data has been looked after. That, I think, is a very likely development. There are record-keeping obligations on a data protection officer, but one comforting thing, if any of you are considering whether you might become the data protection officer for your company, is that there's no personal liability attaching to becoming the data protection officer for an organization. The next topic, again, which was trailed earlier today by Rebecca, is the idea of data privacy impact assessments. And what the GDPR says is that where you are processing, where processing involves a high risk to the rights and freedoms of individuals, the data controller should conduct an assessment of the impact of the processing operations on the protection of personal data. And this is an example of where the regulation is going to promote disharmony amongst the member states rather than harmony, because what the regulation says is that the national information commissioners have got to produce lists or guidance of processing activities which are seen as involving high risk. So you can see different countries competing with each other to have either a long list of high-risk processing activities or a short list of high-risk activities in order to encourage businesses to locate in their country or to discourage them from locating. If you are if you are involved in high-risk processing and you don't do a data privacy impact assessment, then you are potentially subject to fines under the data protection legislation. It might be a comfort to know that they're not at the highest level. They are not at fines of up to 20 million or 4% of revenue, but capped at 10 million or 2% of revenue for not carrying out one of these impact assessments where you're supposed to do it. And if you carry out an impact assessment and it shows that there is in fact a high risk in the absence of steps to mitigate the risk, you've got to consult the local information commissioner, the national supervising authority. And the supervising authority has the power to conduct audits, to impose requirements on the processing, to say you've got to do it in certain ways, or if it's dissatisfied, to launch proceedings in the national courts to compel compliance with the regulations. So the data privacy impact is something that you need to keep an eye on, because if you have operations in Europe and they are potentially high risk, you should at least be documenting why you've decided not to do a data privacy impact assessment. If you follow the guidance that's been issued to date, then it looks like lots of activities will be caught. So what the guidance has been produced, the guidance has been produced by the Article 29 Working Party, again last month, says that these are the sort of factors the national information commissioners should be looking at when they're producing their lists of what is high risk. And if you were to look at all of this, evaluation or scoring processing, that's profiling, really. That's credit scoring, that kind of thing, looking at health risks. Automated decision making with legal significant effect. Again, that really sounds to me like profiling. And if you look at the last one, processing which prevents individuals from exercising a right or using a service or a contract, that's things like a bank screening to see if a loan will be granted. I think that's the sort of thing they're talking about there. That, again, really is profiling. And that is something that the authorities are highly focused on, and there is going to be some more specific guidance on profiling, because if you're involved in profiling, then that is a bit of a red flag as to whether or not you should be thinking about doing a data privacy impact assessment. The guidance suggests this kind of rule of thumb that if you've got 2 or more of those present in your activities, then a data privacy impact assessment looks more likely than not likely. They produced some specific examples. If you look at the gathering of public social media profiles data to be used by private companies generating profiles for, they say, contact directories, well, that's got evaluation or scoring and data processing on a large scale. I think that's Facebook. And as it happens, Facebook are now under a new investigation by the UK Information Commissioner about the way in which they handle personal data. So those sort of businesses, I think, are fair and square in the lines of people who are going to be subject to data privacy impact assessments. But it could be broader, could be insurance companies, could be all sorts of businesses like that. I'm pleased to see that the last one, an e-commerce website displaying adverts for vintage car parts involving limited profiling based on past purchases, is not necessarily caught. That's me. The next slide is really just, and it's really a sort of a takeaway rather than to talk about now. That is an example of what the steps that you should take in a typical data privacy impact assessment. To go into great detail on a data privacy impact assessment, I think is really, it's another topic in itself. But what should you be doing now? There is no reason why you should wait until May 2018 to be conducting data privacy impact assessments. That's something you could start doing now. You might consider what common processing activities are carried out so that you could perhaps limit the number of data privacy impact assessments. There may be a number of activities you do which are essentially the same, but in slightly different contexts. And if you can find a way of doing an impact assessment of the common features, and one might be monitoring the workplace at a number of workplaces that you operate. Well, that might be something you could do. You could split that up into, you wouldn't have to do a complete DPIA for each set of premises, I think. If you were making new technology available to people, so if you were producing the killer app which enables an insurance company to price risk for a new product, maybe you could do the kind of vendor due diligence. You could produce your DPIA and show it to your customers and say, look, this bit of the process is DPIA compliant. What you do on top is your business, rather than give the components to the insurance company or whoever it is and let them work out what to do. You could, as we did for somebody else or somebody a few weeks ago, you could structure the business arrangement so that the person doing the what you might call the profiling is doing it entirely on anonymized data, so that there is no personal. They just take it out of the personal data realm, and therefore you are not having to do a DPIA for the activities you're doing with anonymized data. That would be another trick. Quickly on to a data subject's right to data portability. This is a new thing in. This is definitely a new thing in the regulation, and the objective is to empower data subjects to prevent them being locked in to suppliers, so you can get your playlists out of Spotify or iTunes and send them to Spotify or iTunes if you haven't. But it's important to understand that the limits on the right of data portability. It only applies to data which somebody has themselves supplied to the data controller, and it's data about themselves. And the data subject has a right to ask for it in a form in which they can use it themselves or give to somebody else. And the data controller has got to do that within a certain period of time. There's an issue here about what is the data provided to the data controller by the data subject. So it includes observed data. So if you are a data controller and you get some data from somebody, but you say the playlist thing, you observe that they are particularly interested in jazz of the 1940s, or you're maybe a supermarket loyalty card operator and you observe what people buy in shops in the supermarkets. That is information which you have got to give back to the data subject or to an alternative supplier, if that's what the data subject requests, on demand, because that's data you've observed. And that seems to me to be quite a serious threat to some of those businesses, because that observed data is quite valuable. It doesn't extend to derived data. So if you've done something to the data, you've processed it, put it together with some other data set, then that's not caught by the right. But the right, the portability right, including kind of observed data, seems to me to be quite powerful. So what should you be doing? Well, actually, there are two sorts of data controllers. The data controller who is being required to disclose the data, and the data controller to whom the data is being transferred. And I think if you are operating a business where you are likely to be subject to a request from a data subject for data portability, you need to be clear that you can do that. You need to have appropriate measures with whoever you've got your contracts with for processing personal data, so you can get it back. You need to be clear that you can separate the individual's personal data from somebody else's personal data. And you've got to do it within a month. And if you're the recipient, are you getting the data as a data controller, or are you getting the data as a data processor on behalf of the data subject? It matters because you have obligations to tell people what you're doing with personal data. I don't think that's probably not such an important obligation if you've been given it by the data subject, but what you can do with the data as a data processor is much more limited than what you can do with it as a data controller. So these are all quite, each of these topics is probably worth a session, but they're all concerns, I think, in the light of the regulation. The last point before I hand over to Kendall is consent as a basis for processing personal data. And you would think that if you had the consent of the data subject, that would be the best basis on which you could operate to process personal data. In fact, it's probably the worst basis, because the data subject can at any time say, I withdraw my consent, and then you are stuck about how you can process the personal data. But in some circumstances, consent is the only basis on which you can rely on. You can rely on for processing. And there's been some guidance issued by the UK Information Commissioner about what is meant by consent. And they basically say that the new features of consent are that it must be unambiguous, and there must be a clear affirmative action showing consent. You can't infer consent. I'm not absolutely sure, but I think both of those concepts are actually in the current directive. So I think there's something else going on in a political sense between the UK Information Commissioner and the Article 29 Working Party about who's pumping out guidance on what, but it doesn't really matter. We don't need to worry about that too much. If you take this guidance at face value, the good thing is the UK Information Commissioner's guidance is you don't need to do anything to repaper arrangements you've got in place at the moment for consent, but where you are applying for consent, where you're going to use consent from now onwards, you should make sure the consent is kind of clearly unbundled from other terms. You should use active opt-ins, and I think one thing you should think about is really whether consent is the basis you should rely on, because if you rely on consent as a basis for transferring, then you've got, amongst other problems, potential problems, you've got this data portability thing, because you see the data portability right applied if it was consent or as a result of performing a contract. You could be processing data for all sorts of other reasons, and you wouldn't have to have agree to data portability. So it might be that it's a time to be thinking about whether consent is the basis on which you should be processing personal data.
Thanks, Mark. So Mark just explained some of the biggest changes with the EU GDPR from the prior European Data Protection Law, which is called the 1995 Directive. One of the major jurisdictional changes to the GDPR, however, was to expand the law of application so that European data protection law doesn't only just apply to companies that operate in Europe, but also applies to companies in other countries that target data subjects in the EU and requires them to also comply with the GDPR components. So that's a pretty fundamental change from the scope of the GDPR as compared to the 1995 EU directive, and is one of the reasons why this is such a significant new data protection law around the world. I'm going to talk about one of the aspects of the GDPR that hasn't changed, however, and that is the requirement that any company that it receives personal data from subjects in the EU has the legal right to do so. And under the EU law, whether you're talking about the directive that is currently applicable right now, or if you're talking about the GDPR that will come into effect next year, you're only permitted to receive personal data from EU if you are located in a country that is considered adequate by the European Union, or if you're using one of the other legal mechanisms of data transfer. So what does that mean? First off, just to level set, the United States has never been considered an adequate country by the EU to receive personal data. That means that every company in the United States that receives any kind of personal data from the EU has to utilize one of the other approved means. I've listed 4 of these here above. The top 2 are the most commonly used by U.S. companies. The first one is EU model clauses or standard contractual clauses, and I'll explain in a little bit what those are. The second one is Privacy Shield certification, which is the main topic for my presentation. And in case you don't know what Privacy Shield is, you might be familiar with its predecessor, the Safe Harbor framework. But it is, again, one of the more common legal ways for U.S. companies to receive personal data from the EU. And it's been a subject of a lot of conversation and change over the last year or so. The third approved means for receiving data are binding corporate rules, which is really only a legal mechanism that is useful for groups of companies or multinational companies to receive data between themselves. It's not a viable means of receiving data from an outside group or party or individual. So it's not useful to the majority of companies necessarily. And then there are other specific derogations within the EU law that allow for transfers of data in specific situations, which could include simply approval by the data protection authorities in Europe, which is sometimes hard to get, obviously. But again, so the bottom line is that these top 2 are what we really focus on right now, which is the EU model clauses and then Privacy Shield certification, because these are the most popular for U.S. companies. Okay. So what are Privacy Shield and model clauses? Privacy Shield is a new framework, relatively new framework, that was agreed to by the European Union and the United States at the end of the summer last year. And the reason why it's significant is because it was a replacement for the Safe Harbor framework after the European Court of Justice invalidated the Safe Harbor framework and said that it was inadequate in terms of protecting EU personal data under the fundamental rights of Europe. So that was a very important decision, and it left some U.S. companies without a legal mechanism to receive data. And so what happened is it sort of spearheaded a negotiation between the United States government and the EU to come up with a new framework that would require changes on the behalf of the U.S. government in some ways, and changes in terms of what U.S. companies would do, promises that they would make to the EU data subjects on how they would protect their data, so that the EU would say that this is an adequate legal way in order for U.S. companies to receive personal data. So that was a highly negotiated framework, and it was approved at the end of the summer. What the Privacy Shield requires is a number of things. First off, in order to even certify to the Privacy Shield, you have to be a U.S. company that is under the jurisdiction of the Federal Trade Commission or the Department of Transportation. And that is because one of the key aspects of the Privacy Shield framework is that you are essentially making promises to EU data subjects that are enforceable by some body. And that body in these cases is the FTC or the DOT. So it operates much like what the Section 5 authority that the FTC has that was in the topic of another presentation, so that the FTC has a check on what your Privacy Shield certification means in terms of how you're complying with it. The other aspect is that there's a number of principles that fall under the Privacy Shield framework that companies have to certify to. And if you're familiar with the Safe Harbor framework, or if you're familiar with Privacy Shield, these will be familiar to you because they're in some ways replications of the Safe Harbor framework. But those principles are notice, choice, accountability for onward transfer, security, data integrity and purpose, limitation, access, and recourse enforcement and liability. So what Privacy Shield requires is for those principles, which I'm not going to go into, I don't have time to go into detail on what each of those principles means, but for your privacy policy basically to accord with what those principles are in the Privacy Shield framework, and for you to take certain operational and policy steps to comply with those principles. Effectively certify to the Department of Commerce that you're promising to uphold these things, and have those be enforced, you know, if they're abridged or if someone has a complaint with the Federal Trade Commission or the Department of Transportation. So that's the lay of the land on the Privacy Shield. In terms of differences with the Safe Harbor framework, in my opinion, the majority of the differences between Privacy Shield and Safe Harbor lie with the U.S. government and not with the obligations on private companies. That said, there are some key differences in terms of, if you're familiar with the Safe Harbor framework, there are more obligations in terms of the onward transfer requirement under Privacy Shield, and there's a new operation for recourse enforcement and liability under the Privacy Shield. There's some other changes in some of the components of the principles, but those are the two main areas where we see differences. For model clauses, on the second side, those are useful for companies. Those were what a lot of companies could only rely on after the Safe Harbor framework was invalidated. And what model clauses offer are sort of very standard clauses that can be included in contracts that allow a EU company to share personal data to a U.S. company, and you have different versions of those contracts depending on how you're situated in receiving that data and what your purposes are for that data. Those clauses cannot be revised or changed. They're very straightforward, but one of the main aspects is that they create liability, giving the data subject the direct right of action in the EU. I'm going to take a little bit of time to talk about the onward transfer principle in Privacy Shield, because that's a significant one in terms of companies that have certified to the Safe Harbor before and are now looking at how to comply with the Privacy Shield framework, either because they're looking to certify now or because they certified early and they're now looking at how to accommodate their onward transfers. First off, there's different obligations in the Privacy Shield principle for onward transfer depending on if you're transferring it to a data processor or a data controller. This is sort of a fundamental distinction in EU data protection law, which can trip up those of us with a U.S. perspective. But what the EU looks at is whether you're a data controller or a data processor in terms of whether you are doing with the data exactly what the person who's passed the data to you has asked for you to do. Are you providing a service? Are you just storing in a cloud? Is this part of your business operations? Those are the types of activities in which we consider it to be a data processor or a third-party agent. Or if you're a data controller, you have your sort of own free will over the data. You're using it for your own purposes in addition to receiving it for other reasons that the other data controller gave it to you. And so those are important distinctions that are cut across all the EU data protections law, including GDPR. They're more complicated than I gave them right now, but that'll give you a sense of what we're talking about when we're talking about why there's differences within the onward transfer principle. There's different liability requirements depending on whether you're standing as a processor or controller, and there's different expectations in terms of what you might do with the recourse principle in the Privacy Shield. The second aspect I would emphasize in terms of why onward transfer is particularly important is because the Privacy Shield requires that you only transfer data that you've received under the Privacy Shield to an entity that will provide an equivalent protection to the Privacy Shield. It doesn't mean that they have to be certified to the Privacy Shield, and it doesn't mean they have to do exactly what the Privacy Shield promises, but it has to be equivalent. And what the Department of Commerce has said to us is that that could simply be the obligations under the model clauses, under the standard contractual clauses in their mind is equivalent to what the Privacy Shield offers. Okay, so now we get a little bit to the fun part on this issue. We get asked a lot of questions about sort of what is the future for Privacy Shield and for model clauses. These are topics that are hot right now in Europe. If they're not hot in this room, they're definitely hot in Europe. They have been subject to 2 legal challenges. So first off, since Privacy Shield was finalized at the end of the summer, there is a legal challenge to the Privacy Shield raised by a privacy advocate in Europe under the same theory that invalidated its predecessor under the safe harbor. Similarly, there's a legal challenge to the model clauses in Europe, also under the same theory. And what these two have in common is that what the privacy advocates are saying is that the U.S., the primary means of accepting personal data into the U.S. are not adequate under EU law because of what they believe U.S. intelligence agencies are capable of doing in terms of collecting personal information. And so in terms of the argument about what the challenges are about, that's the prime area of concern. That despite, the changes and the improvements that were made in the Privacy Shield framework, despite the fact that model clauses have been around for a really long time and haven't changed at all, that they do not address U.S. government activities around personal data in Europe. And, no matter what changes U.S. companies make, that is not going to address, obviously, what the U.S. government is doing on their side. Luckily, I think the U.S. government did a lot of work in terms of their Privacy Shield certification, demonstrating how they comply, how their intelligence activities do not run afoul of EU fundamental rights. I think you'll find in the discovery aspect of these cases that there was a lot more information and care provided in what both the friends of the court and also the parties involved were able to say about what those activities are. And I think it's possible that there will be a different result in those cases, and we're not just seeing a repeat of what the Schrems decision was that invalidated the safe harbor. Nonetheless, those legal challenges are out there, and there could be decisions in those cases which invalidate, either of those legal mechanisms of data transfer, and that would put U.S. companies back in the situations that they were, when the Schrems decision happened. Secondly, there's baked into the Privacy Shield framework, there's an annual review mechanism which comes into play this September. And basically both sides, the EU and the United States, get an opportunity to review, give their opinion over how the Privacy Shield framework is working, make any tweaks that they believe is necessary, or even invalidate the framework altogether and step away. So that, in fact, I think is where more of the attention at this point is being paid to what possibly could be a negative outcome for Privacy Shield, whether that in that review process that will happen in September, whether the EU will come away and disavow the Privacy Shield framework. And there's a couple of main areas of concern that we know that the EU has over the Privacy Shield, and I'll just share them generally with you now. First off, one of the main asks of the EU with regard to the U.S. government commitments in the Privacy Shield framework was to appoint an ombudsperson within the State Department who could effectively address EU data subject concerns with regards to U.S. intelligence collections over their data, to be a little bit of a neutral and independent party within the general government apparatus and to hear those concerns and requests. At this point, there's no permanent person filling that role. There's someone who's acting with a capacity and responsibility for that position, but the fact that there is no permanent person has been raised as an issue within the EU. And it is a significant role both for the EU and also for what the Obama administration effectuated after the Snowden disclosures. And one of those main things was the Presidential Policy Directive 28 was really a cabin on, in some ways, a statement of principles around U.S. government collection, and included a call for a type of position like the ombudsperson. It also included, basically a statement that the U.S. U.S. government does not willy-nilly collect information about foreign citizens just because it can, and include a description of how they would include greater protections, somewhat in response to the concerns of Europe after the Snowden disclosures, which is always in the background of these discussions. PPD 28, the Presidential Policy Directive, can be changed, obviously, at any time by any other president. If there was a change to PPD 28, I'm certain that we would hear intense cries of frustration and concern in Europe, and I would be very worried about the future of Privacy Shield if there were changes to that. The one in the middle is also one we get questions on in terms of whether there have been changes to the Privacy Act protections that may apply to the EU citizens. Like the ombudsperson role, one of the main asks of the EU was for EU citizens to receive certain privacy rights with regards to how federal government processes their data. Right now, all of us as U.S. citizens have rights in the Privacy Act about how the U.S. government processes our data. EU asked for that to be sort of accorded on their end so that the EU citizens would get those rights extended to them as well. That was accomplished in a piece of legislation called the Judicial Redress Act, which was signed right before the Privacy Shield framework was finalized. There was question and concern about the longevity or the application of that piece of legislation when an executive order that came out recently that seemed to suggest that the Privacy Act would be limited in some way by for foreign citizens. But I think the EU it's been explained a couple times now at this point that the executive orders cannot override existing legislation. So the Judicial Redress Act stands, and it allows for protections for EU citizens in the way that hopefully the EU will still appreciate. Anyway, so those are sort of the three triggers I see down the road in terms of what the review at the end of September will look like for both the EU, on the EU side, and what that could mean for the U.S. I hope I've given you some landscape of what to predict on these legal mechanisms, and I think Mark and I are both happy to answer any questions. I know it's the end. Yeah.
So is this protection only for individuals, or would it also cover B2B type information that's collected?
In terms of what is covered under the Privacy Shield?
Correct. Or,
it can, I mean, I don't know what B2B exactly means, but if B2B includes personal data, if it includes HR data, if it includes, you know, any personal data like emails, then that is considered personal data by the EU.
So what about like purchase data from a company that we're doing business with?
If it includes personal information as part of that purchase data, then I think.
So if you had the contact details of the people you were dealing with at the supplier, then that bit of it would be personal data. It'd be low-grade personal data, but it would be personal data. Okay.
And it may be covered under one of the derogations that I didn't discuss, but you could look at that too. Anyone else? Hey, Margie.
Hey, Mark, I was actually, in all the discussions that I've been to on the GDPR, surprised by your mention that if the IT officer, for example, in your company was the person that you were thinking about choosing as the data protection officer, that person would have a conflict. So I was hoping you could explain a little more about what are the conflict situations they're looking at, because I think for many U.S. companies, a lot of the monitoring of the data privacy is often a cooperation, frankly, between legal and sometimes the IT infrastructure, because they know how the data is being collected and sorted and used, or they're the best collectors. So
that was my speculation, that the person in charge of data processing and the budget for data processing, or the person in charge of the information security budget, would be the sort of person who would be in a conflict if they were saying, well, actually the measures you're taking to protect personal data are not adequate, because on the one hand they'd have a budget which presumably would be harder to manage if, wearing your other hat, you said you've got to spend more on looking after data privacy compliance. Okay, I might be wrong, but that's just what I thought that must mean.
Okay, but that's why I'm just trying to understand what is a conflicting situation. So it's not how you're interacting or using the data, but it's a conflict in your responsibilities as to how much resources or whatever you're going to devote to one versus the other.
Conflict of interest, I think,
Okay.
There are independence requirements for DPS if you have that. That's not an interpretation.
Hey, Mark, at the risk of delaying cocktail hour, I did have a question about, say, in the case of banks where you have a customer agreement with a corporation pursuant to which the corporation is providing, among other things, personal data regarding individuals, but the bank has no agreement directly with the individuals. How can you get the consents? Is it sufficient if the corporate customer represents that they have the consents to give you the data?
Consent is only one basis on which you can be permitted to process personal data. So I think if you've got personal data which you're holding for, say, regulatory reasons, for KYC purposes, that is not data that you need to get on a consent basis. You might get it on a consent basis, but you might acquire it from all sorts of other sources, and you might hold it for the purpose of KYC, and that would not be, I don't think, that's not data which would be subject to a portability requirement at all. That would be just data you've got. I don't know if that answers your question, but it is close to having a drink time, so I think you're probably going to say it is.
Well, thank you very much.
Yeah.